Good morning, I'm Michles, and welcome to this week's installment of the Michles and Booth video blog, where we try to address some of your concerns and some of the issues in the practice of plaintiff's personal injury law. I'm, of course, Marcus, and I've been doing this for almost 30 years. I tell people that if I worked for the railroad, I'd be due a watch by now. But over the course of my career, I've seen an awful lot of changes, as you would imagine. The law is a living thing, and it evolves and it moves from year to year. Indeed, right now over in Tallahassee, we're in session, and that means that all the politicians are in full gear, and bills are being passed, and laws are being passed, and existing laws are being manipulated. And sometimes that's for the better, and sometimes it's for the worse, depending upon your political frame of reference or your point of view. But I want to talk to you a little bit about the Medical Malpractices Act this morning. We haven't talked about medical negligence in a while, and I always feel the obligation to give this disclaimer. We enjoy a tremendous blessing of the gifts of medicine in this country. If you get into a car accident, an ambulance comes. They don't ask you for a credit card or cash. They come and they take you to the hospital. And the hospital may ask you for some things, but if you don't have money in your pocket, you're going to get treated. And you're going to be saved if you're gravely ill, and you're going to get the state-of-the-art health care that everybody else in this country really gets. Now, there's a big controversy about how to pay for it, and I'm not here to talk about that today. But in the medical negligence world, if a doctor or a nurse or a healthcare provider makes a mistake, under our theory of civil justice, they're responsible for that mistake. And that doesn't mean that it doesn't make them a bad person, doesn't make them an evil entity, it doesn't make the industry a questionable industry. It doesn't take away from the many wonderful things that healthcare providers do every day and the miracles that they perform every day. But it falls into a very specific, to me, a very limited personal responsibility kind of thing. I mean, it boils down to, if you make a mistake, you're responsible. We were taught that as children. If you spilled the Kool-Aid, you cleaned it up and you made it right. You were responsible for your actions. Now, there are some tremendously unique facets to Chapter 766, which governs our medical malpractices laws. Very unique protections are afforded to healthcare providers. They have very special circumstances. One of those is the very short statute of limitations. Many of you may not realize that the 4-year standard negligence statute of limitations, that is, the period within which to bring a claim, is only 2 years for medical malpractice. You have just 2 years to bring that claim. Now there's a decision, Tanner versus Hartog, which says that you have 2 years from the date that you reasonably could have known about the malpractice, but that's very narrowly construed. Generally, you have 2 years to bring the claim. It's a shorter statute of limitations by half. Here's another unique facet to the Medical Malpractices Act. I tell people, if you want to sue the president today, all you need to do is reach into your pocket, pull out a cocktail napkin or a piece of paper, scribble down your complaint, take it over to the courthouse, and file it with a filing fee. And you have sued the President of the United States. You can sue a politician, you can sue a Supreme Court justice, you can sue the mayor, you can sue anybody just like that today if you chose to. But you can't do that to a doctor. You can't do that to a hospital or a nurse. Unique to Chapter 766 and a unique protection afforded medical healthcare providers is this. If you have a complaint, you have to file what's called a notice of intent to file a complaint. In other words, I want to sue you, but I can't do it just yet. With that notice of intent, you need to supply an affidavit, a sworn statement, from a similar healthcare provider. If it's a doctor that you're suing, it has to be a doctor of the same specialty. If it's a nurse of the same practice and experience. But you've got to file an affidavit with your notice. Well, those affidavits are costly, right? You have to hire an expert witness to sign an affidavit just to sign a document that says we intend to bring a claim. And that starts a very unique process known as the pre-suit screening process, which runs for 90 days and allows the defendant to get their house in order, take statements, and to conduct discovery. And all of that happens before the plaintiff or the injured person has the right to bring a claim. That's pretty significant. It's pretty expensive, it's time-consuming, and it's very hard to comply with. It makes it just hard enough to where maybe if you're on the border of bringing a claim or not bringing a claim, you just choose not to. Makes it just hard enough and just expensive enough that many of those claimants can't really afford it and can't really justify it. Which brings me to a couple of other concepts about the Medical Malpractice Act. Many of the people that call us, and we get about 50 calls a week complaining of medical malpractice. Many of them are misunderstanding what happened. Many of them, their expectations were unreasonable. Very few of them are actionable medical malpractice claims. Very, very few. But the 50 people that call generally misunderstand a couple of concepts I want to discuss with you this morning. One is the concept of causation. It means that just because something happened to you that was negligent, just because someone made a mistake, doesn't mean it's actionable in court unless you suffered specific damages as a direct result of that mistake. For example, we get calls frequently where somebody was given the wrong medication. A mix-up occurred in the hospital. They were given a pill or two that wasn't directed to them, and you know that pill's got a laundry list of side effects, right? But in reality, that mistake produced, let's say, no physical manifestation of illness, no physical manifestation of injury. Under that circumstance, you would have negligence. Somebody gave you the wrong medicine, but you would not have damages that resulted from that medication. So you would not have established the principle of causation. The negligence caused a specific injury. Now let's say that it did. Let's say that you got the wrong medication, it made you nauseated, you vomited, and you got rid of that medication, and it was a bad night for you. You would have damages, right? You would have suffered through a 24-hour period of illness. But then you got better, let's say. Under those circumstances, the cost of bringing a claim would far exceed the reimbursement you would likely obtain from the claim. Remember that pre-suit screening process and that affidavit? That affidavit from an expert might cost $3,000 to $5,000. Let's say you missed a day of work. You lost a couple of $100 in wages. Well, nobody spends $3,000 to get back $200. And there's no punitive damage claim under those circumstances. So without causation, you have no claim. And if you have nominal damages, minimal causation, it may become cost prohibitive to bring a medical malpractice claim. And I'll tell you, with caps, that's another unique feature, that another unique protection for doctors and healthcare providers is there's a cap on damages. That cap can be as low as $250,000 in a death case. So you can imagine proportionately what the cap can do psychologically in making that one day you miss from work cost efficient from a medical malpractice claim standpoint. Let me tell you one more issue, or a couple of concepts unique to the Medical Malpractice Act. That concept of causation, think about this. Let's say you slip and you fall and you bang your elbow. You go to the emergency room and they take an x-ray and they say your elbow's not broken, put some ice on it, take some Motrin, have a nice day. And you go home, you put some ice on it, you take some Motrin, but after a week your elbow's still really swollen, it still really hurts. So you go back to the emergency room, you get another x-ray, and lo and behold, they see that it's fractured. Well, they put you in a cast, or a splint, nowadays more likely a splint or a fiberglass Velcro cast. And after a couple of weeks you get the cast off and your elbow's good as new. Well, there was certainly negligence on the part of the first radiologist, let's say, who took the first x-ray, or the doctor who read that x-ray who said it wasn't broken. You can claim clearly there was a mistake made there. And you went 7 days with your elbow hurting, but then they found the fracture and they gave you the exact same treatment they would have given you a week earlier, which is put you in a cast and a splint. You get out of that cast or that splint and your elbow's fine. You don't have causation. You have negligence. Somebody missed that fracture on a film. But you don't have any real change in circumstance. So you don't have an actionable medical malpractice claim. Finally, I'll leave you with this concept that's very important to medical malpractice, and that is the concept of a known risk or a recognized risk of a procedure. Let me take a very simple example. Let's say you're going to get general anesthesia. Well, you get put to sleep, and 99 million times out of 100, there's going to be no problem. You're going to wake up, you're going to be fine. But there is a recognized percentage of anesthesia reactions where people don't wake up. That's why you sign those consent forms, right? It happens. I'm fortunate that I've never seen it happen, but it happens out there in the realm of possibility. In the Medical Malpractice Act, a recognized risk or a recognized complication of a procedure is not negligence. Just because a bad event happened doesn't mean that somebody did something wrong. And that's codified. That's in the statute for medical malpractice. Doesn't exist elsewhere. It's very, very difficult to prove medical malpractice when there's a complication that occurs that's recognized as a risk. Best example I can give you is MRSA or infection. There's no such thing as a perfectly sterile field. As long as an operating room's rate of infection is low enough, it qualifies as a sterile environment. If you get an infection after a surgery, for example, if you get MRSA or another type of infection, staph infection, that's not necessarily evidence of negligence, because a recognized rate, a recognized percentage of people get infections post-operatively. So in the medical malpractice world, you've got to prove negligence, you've got to prove causation, and you've got to prove specific damages that are a result of the direct negligence. So don't think that just because somebody made a mistake, you have a claim. And don't think that just because there's a bad outcome, you have a claim. If it's a recognized risk or a known complication of that procedure, it could very well fall into a category where it happens to the best of doctors, it happens to the best of nurses, there's a recognized percentage of failure or a recognized percentage of complication that is not the product of negligence. Now that's a mouthful, and I've said a lot. It's a lot to digest. Bottom line, from my perspective, is this. Doctors and nurses, healthcare providers, and hospitals do amazing things every day, but they're still responsible for their mistakes. But the statutes that govern that are very, very difficult, very, very tricky, and require some significant expertise on the part of the lawyer or the law firm handling the file. If you think you've been the victim of medical malpractice, talk to somebody quickly, because that statute is short, and understand there's a lot of hurdles you got to get over to make a successful claim. I'm Marcus Michles, and on behalf of the Michles & Booth Law Firm, and you can go see us at forthevictims.com, you can go see us at forthevictims /blog, and you can see our video installments. If you've got suggestions or questions, give me a call. I'll be happy to talk to you about them. Until next week, I'm Marcus Michles again for Michles & Booth.